Thank you everyone for joining us. Today we've got a webinar on children's rights and the law in the time of coronavirus. You'll have seen we've got a panel of 4 today: Aoife, Nolan, Gallagher, Adam Wagner and Jamie Burton. We're expecting today to last an hour and it is being recorded, so will be available to be shared with colleagues who are unable to attend if we need to. For those of you who haven't joined a webinar before, you will be muted and your cameras are off. This is just to stop any interference and distractions for the panel. We're asking that you use the Q&A function to send through any questions that you'd like the panel to answer, and we'll endeavour to do so at the end, and if we can't get to them, we'll be in touch subsequently to pick up on anything arising. If you've got any questions for me in the meantime, I'm sitting in the background as the host, so to speak, so again use the Q&A function. But I will pass over to Aoife, who is our first speaker.
Okay, thank you, Sian, very much. And thank you very much, everyone who's come today, and to Sian and to others at Doughty Street, including Caoilfhionn, for having organised today's event. As Sian said, it's the first of a series of seminars that the Children's Rights Group at Doughty Street Chambers is hosting on children's rights and the law in a time of coronavirus. We'll come back with further details at the end, but just to note that this is the first of many rather than a one-off. So what I'm going to do today is I'm going to speak about, I'm going to focus on the issue of children's rights. And let me just pull this up now. Excuse me for my technical incompetence. And children's rights and COVID-19, setting the international scene. So what I'm going to begin with is start with some of the facts, what we know, because obviously this is very much a situation that's in flux. And what we know, and I'm quoting directly from a UN policy brief, is the fact that children, while they're not the face of the pandemic, they risk being amongst its biggest victims. And certainly that is true in the context of the UK, where children are very much proving to have been both the unforeseen and until recently largely unseen victims of COVID-19. And obviously, if we look globally, because I am giving the international scene, we see the current and predicted impacts include a sharp predicted increase in child poverty globally, huge losses in childhood learning worldwide, leading to school closures and digital exclusion, and entrenching of educational inequalities, a risk to child safety posed by lockdown and shelter-in-place measures, and wide-ranging implications for child health and survival due to, amongst other things, the impact of the lockdown in the short term and in the longer term for access to healthcare services, water and sanitation, etc., etc. Leaving aside the mental health impacts of COVID-19 and lockdown, which are themselves potentially immense. And I think one of the things that needs to be, very much the scene needs to be set when we go from the international to the domestic, is that the fact is that COVID-19 and the UK government's response to COVID-19 have laid bare, made clear and exacerbated pre-existing long-time structural inequalities and social vulnerabilities in the UK. And this is particularly clear when we look at children. So moving on, what we see here in the UK, those of you who are taking part in this webinar will be, as familiar with this as I am. Just some of the examples: school closures, reduced access to food, rising deprivation in households for children. We see Child Poverty Action Group's great work on this. A disproportionate impact on socially vulnerable children. We see the decision that came out today, led by the Project 17 UK on the no recourse to public funds, a particularly vulnerable group, the children of people without access public recourse to funds. Clear impacts on disabled children, particularly in an educational context, children in poverty, etc., etc. We see the impacts of poor housing on homebound children. Okay, so long-term problems in housing that are obviously more aggressive or more pressing when children are homebound. We see very worryingly increased evidence, some of it anecdotal, some of it based on calls to helplines, of increases in domestic violence and child abuse. We're seeing something that will certainly come to the fore in discussions over the next few months, family rights impacts. We've already heard about disruption of custody arrangements. There's also the issue of children's rights to have connections with those who care for them, for instance, grandparents, etc. We'll be hearing later on from Jamie and from Adam about temporary changes to service provision and legal duties in relation to vulnerable children. I put temporary in quote marks. We can come back to that. And then obviously the mental health impact. So these are just some of the issues we're seeing. So all very nice, but you know, what does the CRC, what does this UN treaty that the UK has volunteered to be bound by tell us about what should be happening on the part of government, whether national, whether devolved, whether, you know, local authorities, when it comes to ensuring children's rights, okay? So first of all, let's think about some of the rights that are clearly affected by the factors that I have mentioned in passing, okay? So the right to an adequate standard of living, including adequate housing and food, okay? We have school, you know, think about school closures impacting on access to free school meals, etc. The right to freedom from all forms of violence, injury or abuse, right to benefit from social security. Now that children are at home all day, we can see that household incomes are incapable, it would appear less capable of meeting the needs of households than they were when children were at school. Family rights, freedom of association and assembly. We don't talk about this much with children, but of course, you know, we think about climate change, but of course, if we think about children getting together for various reasons, association and assembly comes into play, as indeed does the right to play. We have the right to information. And for instance, there's been a call by UNICEF and others to have the government, and I think specifically the Prime Minister, give a talk directly engaging with children and young people around their concerns about COVID-19. We have the right to the highest attainable standard of health, okay? And we know that COVID-19 doesn't directly affect children as severely as it does, for instance, other social groups such as older persons, but it's very clear that children not being able to, having hospital appointments cancelled, being, as I've mentioned already, placed in dangerous housing, clearly has implications for their right to the highest attainable standard of health. There's the rights of children in care, a particularly vulnerable group that we will return to later on, and the rights of children deprived of liberty and access to justice, the conditions of children who are in youth offender institutions, for instance, and other detention contexts. And finally, of course, I suppose the most obvious one, the impact of school closures on the right to education. Okay, so these are some of the substantive rights. But I want us also to focus on some of the standards that we might certainly have expected, or at least hoped, to have played a role in shaping the way that government at the national, devolved and local levels engaged with the question, COVID-19 and its impact on children. Okay, so the first one, Article 3.1, best interest principle. Keelan will certainly come back to this in a moment when we talk about the domestic legal context. This notion of best interest is a primary concern in all actions concerning children. That is clearly includes all actions in the COVID-19 context. Okay. Article 6, the right to life, survival and development. I have limited time, but it's very clear how some of the issues flagged in the second slide around the situations faced by children clearly have implications for these basic rights to life, survival and development. Article 12 talks about the child's right to express their views in all matters affecting the child. And very serious questions have to be asked. And indeed, I think in a passage that colleagues of ours, Zimran, Samuel and Oliver Lewis will be putting up later today on the Doughty Street Chamber's website, very much engage with this question of the right of children to express their views in the context of COVID-19 decision making. Article 2, and finally, this is the final provision to focus on, but actually it's crucial because the longer that the COVID-19 situation goes on and the lockdown goes on and we understand more fully the medium and longer term implications of COVID-19, we're becoming aware that COVID-19's impact on all groups, every sector in society, but particularly children, differs significantly depending on things like BAME status, socioeconomic status, health condition, disability, nationality, okay? And crucially, the thing about non-discrimination under international human rights law and the CRC is it's not just about saying, I will not do bad on the face of it, discriminatory things against specific groups of children. Rather, it requires identification of disadvantaged groups of children and special measures of support to be taken to support those children. Okay, and serious questions have to be asked about whether that has in fact happened in the UK. Now, so that's just an overview of the convention. But in fact, we're missing a slide here. But I think, never mind, let's continue. It'll be on the updated slides on the website. But I think one of the things that is worth noting is that, in fact, the Committee on the Rights of the Child on the 8th of April, so relatively early on, relatively shortly after the pandemic was declared, actually issued a statement on COVID-19 and the rights of the child. And this isn't a general comment, so it's not even a soft law standard. Rather, it's a fairly quick and dirty set of statements aimed at states to help them give effect to their obligations under the CRC in the time of COVID-19, guidelines rather than a pretense at a legal standard. So what do they want states to do? Well, it's relatively unsurprising. Consider the health, social, educational and recreational impacts of the pandemic and the rights of the child. So child rights impact assessment all the way. That's one way of doing that. We saw it happen in Scotland around their Coronavirus Act, but it didn't happen. There was no specific child rights impact assessment for the UK-wide act put in place at in the Westminster context. There's a huge emphasis in the statement on ensuring that online learning doesn't exacerbate existing inequalities or replace student-teacher interaction. Big emphasis on providing adequate nutritious food. The need to define core child protection services as essential and ensure they remain functioning and available, including home visits wherever possible. The need to provide mental health care support. The need to protect children whose vulnerability is particularly affected or exacerbated by the pandemic. Crucially, for those of us working in juvenile justice, release children from all forms of detention wherever possible, include, and if that isn't possible, ensuring they can receive visits from their families and others. Okay. Disseminating, prevent, crucially, given some of the stories in the media, prevent the arrest or detention of children for violating state guidance and directives relating to COVID-19. Very important, an emphasis that children should not be targeted for their, or in fact punished for failure to comply with COVID-19 guidance and directives. The need to provide children with child-friendly and accessible information on COVID-19, and to provide opportunities for children's views to be taken into account in COVID-19 decision-making processes. Okay, and as I say, the final slides on the website will have a link to that statement. I want to finish here because my time is up, but very importantly to note that there are a number of international accountability avenues. These may be of particular relevance to civil society organisations. We all know that the UK's next report to the Committee on the Rights of the Child is due in January 2022. There will be an awful lot to be said when engaging with the committee around its reporting process about the response at the national and the devolved levels with regards to COVID-19. There's also work which we can come back to being done by the European Committee of Social Rights. But finally, and I'll finish here, crucially, the crucial work that needs to be done in the here and now is focusing on domestic accountability. So at this point, I'll hand over to Caoilfhionn. Thank you.
Thanks very much, Aoife, and hello everyone. Thank you for joining us today. As Aoife said, children in many ways have been the unforeseen and unseen victims of the coronavirus pandemic, and that's why this series is so important to us, and thank you for joining us, because we think COVID-19 is obviously a global pandemic that threatens children's rights around the world, exposing them to potential risks and disrupting their lives. And there was, right from the outset, an assumption that as children were considered not to be at higher risk for COVID-19, the focus should be on other groups rather than children. And there's been a belated recognition and a slow, sluggish recognition of the very serious potential impact on children's well-being, psychological and physical, and other rights of children which are affected by the pandemic. So Aoife's given you an overview on some of the international standards, and I'm now just going to set the domestic scene and give you some background before we turn to Jamie and Adam. So first of all, in terms of the impact on children in the UK, in many ways, what we're dealing with here is a microcosm of the global issues for children which have already been identified by Aoife. And there's three broad trends I just wanted to highlight. The first is that many of the risks that we'll be looking at over the course of this seminar series involve an exacerbation of pre-existing threats to children's rights or barriers to realisation of their rights. So what we see with the pandemic is, for example, that issues which are problematic for children already, such as the benefit cap, such as welfare cuts, become all the more problematic when you're faced with a public health crisis and additional pressures on family budgets. Secondly, there are some new threats and risks to children's rights arising from the pandemic and governmental responses. And then thirdly, combined with that, we have a minimisation or a reduction or a removal of certain mechanisms to enforce and protect children's rights, including, for example, matters such as the changes to the regulations regarding children, which Jamie will be turning to later. So those three things taken together are like a perfect storm, really, that causes us very real concerns. And in that sense, the UK is like many other places, but there's also some UK specific aspects which I wanted to highlight immediately. So in the UK, the pace of change has caused some very particular difficulties. I wanted to highlight three at the outset. The first is that certain groups of children have been overlooked given the extremely speedy policy changes which have come about. And we all know our way of life has changed utterly in the course of only 7 weeks. And policy changes which were very drastic and draconian have come in exceptionally quickly. And you see some very particular examples of that, like, for example, when the initial announcement was made about lockdown and people being restricted to their own household, the government appeared to have entirely overlooked children whose parents were divorced and who had shared childcare between 2 households. And suddenly within 24 hours, there was a rushed statement following a confused interview by Michael Gove and mixed messages coming from government. But that's a group of children who were entirely overlooked. Young carers, a group highlighted by the Children's Commissioner, for example, their rights and needs were overlooked right at the outset. Children without access to devices for online learning, also overlooked, and Adam will be coming to this later. You look at the guidance which has been brought out in relation to education. Children were assumed to have ready access to online devices, and the entire focus is on online learning without thinking about the many children who aren't in that category. Aoife touched already on BAME issues. Again, we see with cancellation of A-levels and changes to the way in which university places are going to be given, an apparent total overlooking of the fact that this may cause particular problems for some students. And similarly, access to reproductive rights for girls in Northern Ireland, again, an issue which was overlooked. We just give those as a flavour of some of the issues which were just blind spots for the government as they rushed to make these changes. Second, and closely related, we're finding that equality impact assessments and impact assessments have been produced at helter-skelter, high speed, if at all. So there's been reduced internal oversight within government and within the civil service with this pace of change. And then thirdly, there's been a lack of external transparency and oversight in many ways with these changes. That includes reduced ability for the public or specialist NGOs, many of you who are on this call, reduced opportunity for you to contribute and have oversight, but also we had parliamentary recess at a critical time. All of those things in the UK have caused very particular problems. The domestic framework for children's rights in many ways it's clearly not something I can cover in 4 minutes, which is what I've got now. But what we wanted to flag right at the outset in this first seminar is that children's rights are of course protected in a multiplicity of ways in the UK. In some specific laws in England and Wales, some specific laws in other parts of the country, and in legislation, statutory instruments, statutory and non-statutory guidance. And what we intend to do over this seminar series is, as we touch on each specific topic, the presenter will deal with the relevant laws for each of those specific topics. But today, in seminar 1, we thought it would be helpful to be aware of how the UN CRC and other international standards touched on by Aoife may be relied upon in domestic proceedings. And may I pause there just for a moment to say, in case you can hear the noises off, it's rather disconcerting to be presenting a seminar on children's rights when I can hear my own children making rather a lot of noise, just stage right. So apologies if you're getting heckled by them inadvertently. So the UN Convention on the Rights of the Child, there's three main ways in which the UN Convention on the Rights of the Child can be deployed in the domestic courts and in domestic litigation. This is a very high-level, quick overview. Firstly, under specific statutory provisions. Secondly, under the Human Rights Act 1998. And thirdly, through the common law. And there's, of course, substantial variations in Scotland, Wales, and Northern Ireland. So firstly, specific statutory provisions. Although the UN CRC is an international law instrument, hasn't been automatically incorporated into domestic law in England and Wales, its principles are reflected in a number of statutes. And just by way of example, Section 1 of the Children Act 1989, the paramountcy principle reflects the UN CRC. Section 11 of the Children Act 2004, which imposes an obligation on certain bodies, although not central government, to safeguard and promote the welfare of children. And then Section 55 of the Borders, Citizenship and Immigration Act 2009. They're all particular examples of where the UNCRC is reflected or echoed in specific domestic provisions. It's also expressly referenced in some statutory guidance. Second broad category is the Human Rights Act 1998. And that's because the UN Convention on the Rights of the Child is taken into account by the European Court of Human Rights when it assesses the parameters of the European Convention. And given you in the slides there some of the key references, the well-known Neulinger case, and also there's a very good speech from 2011 by Sir Nicholas Bratza when he describes this as now a well-established principle. So the result of that is, by virtue of Section 2 of the Human Rights Act, because the European Court of Human Rights draws on this material in considering the parameters of convention rights, it's also a critical interpretive aid domestically, and the domestic courts must have regard to it when considering Strasbourg case law. The third broad category is under the common law, and in appropriate cases, courts will be strongly influenced by the rights in the UNCRC due to the long-standing principle of the common law that legislation is, in the absence of express words to the contrary, presumed to be in accordance with international law. And there's a quote from the Smith and Smith case from Baroness Hale in 2006. Even if an international treaty has not been incorporated into domestic law, our domestic legislation has to be construed so far as possible so as to comply with the international obligations which we've undertaken. When two interpretations of the regulations are possible, the interpretation chosen should be that which better complies with the commitment to the welfare of children, which this country has made by ratifying the UNCRC. So that is a very quick, high-level indication of how the UNCRC can in general be used. And our speakers over the course of this series will talk about how the UNCRC and other international materials can be creatively used in very particular contexts. Just before I hand over to Jamie, as we've been selecting the topics to look at in this seminar series, we've been very alert to the fact that hardship discriminates. And Aoife mentioned earlier that what we are seeing is an exacerbation of certain pre-existing inequalities with coronavirus. And many of the impacts upon children in the UK involve poverty in some shape or form. And they involve a combination of an exacerbation of existing disadvantage and then a minimizing of the ability for the child's family, the child's advocates to secure justice and accountability for the breaches of their rights. And we are very open, we're conscious of the very wide expertise in the group today with the attendees. We are very open to doing seminars on specific additional topics which we may indeed have overlooked. So please do give us feedback, let us know additional topics that you want us to cover, and we will turn to them. But I'm going to hand over to my colleague Jamie Burton, who heads our community care team and who also founded and runs Just Fair, the NGO, which is very alert to the fact that hardship discriminates. And he's really at the forefront of tackling many of these changes. So Jamie, over to you.
Jamie, you're on mute.
You can tell I'm really used to doing these. Thanks very much, Sian, in particular now, Aoife, Caoilfhionn, and everybody else for tuning in. Obviously, Aoife and Caoilfhionn have set the scene in a kind of macro way, but two things that really kind of stuck out for me and are directly relevant to what I'm going to talk about are just the number of risks that Aoife's second slide identified that are present for children in the current climate, and just how many of those risks are likely to mean that more children need to look to local authorities to protect their welfare, which I think is a highly relevant feature of this crisis. And then Caoilhfionn's point that actually there's been a very slow recognition of that fact. There's a slow recognition of the fact that this crisis has very serious implications for children. And I think that has a lot to do with the fact that initially it was thought that children were largely unaffected in a clinical sense by this virus, which of course we even know that now it isn't in fact true. Let me just, Sian, that problem we had before without me not being able to move the slides on.
One moment.
Yeah.
Right. Just give me a sec.
Sorry, everybody.
Any good now?
Nope.
Do you want me to manage them for you?
Can do. I mean, I don't know quite what it was you did last time to fix it, but I'm very happy to do that. So if you want to move on the slide, then please do. Great, thanks. So what I am talking about today specifically is the Adoption in Children Coronavirus Amendment Regulations, Statutory Instrument 2020-445, and keep that number in mind, and I'll explain why at the end. So what this statutory instrument does is effectively deregulate at least 10 other statutory instruments which contain safeguards and substantive protections for children. And this concept of deregulation, of course, is not unique to this particular statutory provision. It's becoming a common post-COVID-19 theme, at least for our government. It was made with remarkably little scrutiny or public consultation. Again, that seems to be an emerging theme from the post-COVID-19 crisis and legislative response. It affects potentially the most disadvantaged and vulnerable children, and by that I mean children who are in or are likely to be in the care system over the coming months. The changes that this provision brings about did not come out of nowhere, however. Many of them have actually been mooted and indeed thwarted over several years, recent years, from about 2016-17 onwards. And that of itself has raised some suspicions about what the longer term intentions are of this particular legislative change. And that might also explain why there's also been an equally remarkable fight back against these regulations in very short order. And I'm going to talk a little bit about that in due course. Sian? So these regulations came into force on the 24th of April 2020. They were only laid on the 23rd of April, and made on the 21st of April. And that's extraordinary. As most of you will know, the normal rule is that any regulations will only be laid as a minimum 21 days before it's intended that they should come into force. The reason being there should be proper scrutiny if there hasn't already been, and indeed consultation. The government's case on this is they simply did not have time. That after the lockdown was imposed on the 23rd of March, it took them a while to realise what the implications of this would be for children in care. And as soon as they became aware of those things, they drew up this regulation and all of the changes it makes to all of the other regulations which govern care for children. The changes are due to expire on the 25th of September 2020, which is the same date, I think, for the first review of the Coronavirus Act. Just keep in mind, however, that when we're going through some of these changes, the law as now amended by this statutory instrument has it that any changes which are introduced during the period during the period that this statutory instrument is in force will subsist thereafter. And local authorities will be required to treat those particular scenarios, whether it's a decision that's been made or a placement that's been made, as if this law still exists in relation to that particular child. And that's a pretty profound difference in terms of this legislation and some of the other changes that have been made as part of the coronavirus sort of legislative response. As I've said already, there's evidence that a lot of these changes have been tried in the past, not least because some of them have actually been contained in draft bills. They didn't get onto the statute book because of the extent of the opposition, but there's a worry that this time, through this route, the government and those who are proposing these changes succeed, and some of them will last longer than the statutory instrument currently suggests they will. And as I say, there has been extensive opposition. Article 39 have done a brilliant job and created a couple of briefings on this, and I have to say I've relied on them quite heavily for these notes. The Children's Commissioner has also had something to say about it, and most recently UK Labour have tabled a motion to annul by early day motion the particular statutory instrument that we're talking about. That doesn't necessarily have huge prospects, but we'll see soon. So what I'm going to do now is just as quickly as I possibly can go through some of the main changes. There are about 65 of them, so you'll be relieved to know I'm not going to deal with all of them or anything like all of them. I'm just going to try and highlight some of the key ones by going through the respective regulations that are amended by 445. So the first ones are the care planning, placement and case review regulations, or it's often called planning and placement regulations. Very important ones which govern the nature of children's placements in care. First point to mention is that they changed the regulatory requirements in terms of care planning themselves. Whereas it used to be the case under the old law that local authorities had to produce a care plan somewhere between 5 and 10 days post the placement starting, now they only need to do it as soon as is reasonably practicable, which I've had to use the ASRB letters for, because that's how frequently that expression comes up in these changes. So that tells you quite a lot about the nature of these changes. Another important change in this one is that emergency foster care placements can now last 6 months, not just 6 days. And that's even in the case of foster carers who don't have a pre-existing connection to the child. And that's a pretty dramatic change. Finally, equally dramatic is social workers don't need to visit children in their care placements, according to the old periodic visits, which were 1 week after the placement started and then 6 weeks thereafter. They now only need to visit as soon as is reasonably practical after those time limits, and indeed are entitled to do it by phone. I think it was Steve Broach said in one of his tweets about this, if you're going to say these visits can be conducted by phone, what is it about the COVID-19 crisis that means you can't at least phone the child every 6 weeks, which I thought was a pretty astute point, and again reveals something about the necessity of some of these changes. Sharon, could we move on? So still dealing with the 2010 regulations, care plan reviews themselves, independent reviews of how a particular placement is going, now don't have to take place every 6 months. It's as soon as reasonably practical. And that was one of the specific changes that the government tried to introduce in 2016-17 unsuccessfully. A change that was also has caused particular consternation is the way in which short breaks will now work. Currently, a short break can last up to a maximum of 17 days, or over the period of a year, there can be 75 days spent in short breaks before the safeguards kick in. What the government's change now means is you could have, in theory, a single short break up to 75 days before those safeguards kick in. And those safeguards are the sorts of ones you'd expect when a child's gone in to care. So short breaks obviously for children who are principally being looked after by their parents, but are occasionally given short breaks so their parents can get some respite, etc., in a care home or something else like that. They can now go to those care homes for extended periods without enjoying any of the protections that would normally kick in when a child goes into care. Equally profound changes have been made in the context of fostering. Independent panels to approve or review foster carers will now be optional. That was again another of the changes that were tried in 2017 unsuccessfully. And really important, this is one of the ones which I think is really stark and one of the ones which will have impacts long after these regulations are no longer in the statute book, is that private arrangements for fostering the private arrangements for fostering regulations have been changed in such a way that if a local authority becomes aware, is notified under those regulations of a private fostering arrangement or one which is likely to take place in the future, they need now only visit that particular arrangement as soon as is reasonably practical, and not within the 7 days as was otherwise specified, and then every 6 weeks or 12 weeks thereafter. Why do I think that's so important? Well, the evidence says that children in private fostering arrangements are some of the most vulnerable in the country. There's a very strong link, unfortunately, between private fostering arrangements and trafficking. There's a very strong link between private fostering arrangements and inadequate care being given out to children. That's precisely why we have these strong safeguards in place, which require a visit to take place in a very relatively short timescale. That is now gone as part of these changes. Children's homes regulations. Really big change is that it's no longer the case that when external staff come in to a particular children's home and need to look after the children, that they need to have the requisite skills in order to be able to do so. At least they don't have to if it's not reasonably practical to obtain staff with those skills. Now, on one view, you might think, well, that makes sense because the one issue that we do have here is staff shortages. Well, actually, at the end of April, a survey showed that over 150 care homes, the staff drop-off through ill health was only 5%. So there doesn't seem to be that demand there, which would justify such a dramatic measure as saying that you can now have people who don't have the necessary skills going in to look after these children in care. Similar to that, in terms of standards in children's homes, it's now only a reasonable endeavour provision to make sure children achieve their educational standards. And then there are some other incidental changes, which I won't go through just now. But then the one at the bottom in relation to Regulation 44, the independent visitors at the moment or pre these amendment regulations had to go into every children's home once a month to examine what was happening in there, to look out for any safeguarding issues, etc. Those visits now only have to be as soon as it's reasonably practical. And what does that mean in a post-COVID world where those visits might not be able to happen quite as easily? You know, what is reasonably practical in that context? Of course, we simply don't know. Sian, could we move on, please? And that leads into the other big change, which has apparently been made with Ofsted's approval, which is that they will no longer be required to do 6 monthly visits to care homes which have been graded as inadequate or need improvement. That's a pretty big change. Of course, you might say that if you were having the regular monthly visits that were done independently, that change wouldn't be so seismic. But when you put those two things together, you can see the opportunity for huge accountability gaps. Sian, could we move on, please? Yeah, these are some other changes in relation to residential family centres like mother and baby units and things like that. Again, there's a weakening of the actual standards of care that needs to be provided. They no longer need to ensure that they promote the health, welfare and care and treatment of people who are in the centres. The complaints mechanisms have been watered down, and of course, so have the independent registered provider visits, which would help ensure accountability. Sian, can we move on again? Adoption agencies regulations. These have weakened the requirements to approve particular adoption placements and limited the opportunity for there to be pre-placement reviews ahead of there being orders made. Yeah, so that was an incredibly quick summary of some of the main changes. Each of those has caused significant controversy in their own right. But what's the general theme here? So we've got fewer safeguards regarding the identification and approval of care providers and settings. We've got an extension of informal and temporary care arrangements. We've got absent or delayed care planning. We've got reduction of standards and duties in care settings. We've got a reduced obligation to keep care arrangements and settings under review, and the role of independent scrutiny has been diminished. Accountability achieved through complaints mechanism is undermined by the lack of time limits, and all of this has been done at great haste and in the middle of a pandemic. So it gives rise to the following question. Sian? Is Statutory Instrument 2020-445 necessary in COVID-19 world or an opportunistic road test? And this is what the government minister responsible for the regulation said. I'm not going to read it all out, but you can see that last sentence that I've highlighted. We're allowing these changes to make pragmatic decisions, or allow social workers to make pragmatic decisions through minor temporary amendments to regulations, whilst always keeping children's safety paramount. Well, I'll leave it to you to decide whether or not these changes are minor or temporary. The temporary question, obviously maybe one we can't answer just yet. This is what Jenny Coles, the president of the Association of Directors of Children's Services, had to say, recognising some of the concerns that have been made by some of the groups I mentioned earlier. She says that it's important to recognise that all local authorities and their staff will continue working hard to ensure that we can fulfil our statutory responsibilities to children and young people, particularly the most vulnerable, will remain essentially looked after. And I think the problem with that approach is that, of course, it's perfectly possible to accept that and accept that local authorities and their staff will continue to work very hard. whilst at the same time being very concerned about the loss of hard-edged legal rights, which have, as the British Association of Social Workers have said, been hard won over a long period of time. I mean, the concept of reasonable endeavours is a very dangerous one, or the absence of strict time limits. I mean, you can think about your own professional life. I mean, if I only had to use reasonable endeavours to produce a skeleton argument on time, I might be working very hard and really care about my client, but it doesn't mean I'm necessarily going to get that skeleton argument done as quickly as I would do if I had a real hard and set deadline that I had to meet. And there's a reason why those deadlines are fixed in this context. It's because in the world that existed before we had these deadlines, we saw far too many instances of poor practice, which may have come about not through any ill will or lack of hard work on the part of the professionals involved, but because the demands of the system were too much, or the resources weren't there to meet those demands. Sian, could you just move on? And this is what Anne Longfield, the Children's Commissioner for England, had to say. And this is a pretty strong statement for her. And again, I've highlighted the first sentence. I would like to see all the regulations revoked, as I do not believe there is sufficient justification to introduce them. And we can move on, Sian. I mean, the concern I have about all of this is as follows, that I think there's a real possibility that these changes won't necessarily cause the kind of adverse impacts that those who work in this sector and who've campaigned against these changes in the past, and our like Caroline Willow in her statement has come up now, campaigning against them just now, immediately. You know, it may well be indeed that for a period, local authorities and social workers do genuinely cope. There may be a degree of extra scrutiny just generally because of the crisis. But then the argument that would have to be raised later on against the continuation of these changes will be quite difficult. What will be said against the opponents of these changes is, well, look, even in a time of crisis, we've managed to do it without too many adverse impacts. And what we're being told is that these changes are appreciated by the professionals on the ground because they don't have to spend so much time filling out forms or complying with red tape and can really just focus on looking after the children. And it might be difficult to argue against that. But what we've got to keep in mind that this is also about the long-term impact on these children. 6 months is actually a very long time in the lifetime of a child. A year, 2 years, 3 years is an incredibly long period of time. And it might only be after that kind of length of time that we start to see what the adverse impacts were of not having, for example, proper care planning in place, not having proper reviews in place, and not having the ability to hold providers to account in the way that we could before these regulations were amended. So what can you help to do about this? Well, you could write to your local MP because of the Labour Party's motion to annul and see if they'll support that. You could join the campaign, which has been set up by Article 39 and Caroline Willow, and I've given you the relevant hashtag there. You could, if you're practicing in this area, start writing some pre-action protocol letters to really probe decisions made by local authorities about as soon as it's reasonably practical or reasonable endeavours in the context of individual cases. And of course, you could keep your fingers crossed for the potential legal challenge, which I understand is being mooted by Article 39 at the moment. Okay, thank you very much. Over to Adam next.
Hi everybody. Just to remind you that if you want to ask a question, you can put it in the Q&A thing at the bottom of the screen. You can click Q&A and we'll have about 10 minutes at the end to answer those questions. So I'm going to talk about the right to education specifically. Thanks to everybody for all of your very interesting comments so far. Let me see if I can do this. Okay, I've done the same thing. Here we go. So education during the lockdown. Schools are currently closed, as I'm sure many of you know, indefinitely, and they were closed from the 20th of March. There's been a few sort of contradictory rumours from the press. They may open in part at the beginning of June, but we really don't know. And there's a good chance they will be closed, or at least partially closed, well into the rest of the year. They're not completely closed because there are two classes of children that can attend. The children of key workers, which is a list of people like social workers, NHS workers, some barristers, in fact, who can attend, and also children classed as vulnerable, which are, the government defines a vulnerable child as being in need under Section 17 of the Children Act, that if they have an education, health and care EHC plan, which cannot be met safely in the home environment, have been assessed as otherwise vulnerable by education providers or local authorities. So that's a sort of discretionary assessment, and that might include children who are on the edge of receiving social care, but aren't necessarily. Now, that slide is repeating. Sorry, I've gone. So the fact is that around, I figured out 99% of children who are school age are currently not attending school. And in fact, I think there were recent figures that only about 5% of the children who are classed as vulnerable are attending. So, and in terms of key workers, it ends up being, I think there's about 80,000 children attending school across the UK of a total of a potential cohort of 8 million. So really pretty much nobody's attending school at the moment. So legal duties, it was said in Secretary of State versus Tameside by Lord Wilberforce that there's a fourfold foundation to the educational system in England, and that it is the minister, local authorities, parental wishes, and school managers and governors, or school administration. So I'm just going to take 3 of those to understand what the legal duties are. So the Secretary of State has a duty to promote the education of the people of England and Wales, and to do so with a view to, amongst other things, improving standards, encouraging diversity, and increasing opportunities for choice. And this is all under the Education Act 1996, and those are sections 10 and 11. And if you deal with healthcare law, the structure is pretty much the same as it is for the NHS. The Secretary of State has a duty to promote, but the different public authorities have the duty to deliver. So the duty to deliver the education falls on local authorities, which must, under Section 13, contribute towards the spiritual, moral, mental and physical development of the community by securing education. And that includes primary and secondary. They must promote high educational standards, and they have a power to establish schools. And for our purposes, the important duty at the moment is Section 19, which provides that each local authority shall make arrangements for the provision of suitable education at school or otherwise than at school for those children of compulsory school age who, by reason of illness, exclusion from school or otherwise, may not for any period receive suitable education unless such arrangements are made for them. So that's the duty to make alternative provision for children who, for various reasons, including by reason of illness, cannot attend. You can see why that might be important now. The third group of people who have a duty to educate is parents. So the parent of every child of compulsory school age shall cause him to receive efficient full-time educational suitable to his age, ability and aptitude to any special educational needs, either by regular attendance at school or otherwise. Now, ordinarily, that duty is used, it's basically used to trigger an enforcement duty, an enforcement power. So if a parent is not facilitating the child to attend school or receive some other education, they can be, in certain circumstances, fined or even prosecuted. And in those, but here it's has now a different flavour in this environment, which I'll refer to briefly later. But one thing to note for parents among you who may be relieved to hear this, the enforcement power in relation to Section 7 of the Education Act has been disapplied for the moment. So legal duties under the Human Rights Act, Article 2 of the first protocol, no person shall be denied the right to education. Article 14, the enjoyment of rights and freedoms in the Convention shall be secured without discrimination on a very wide ground of characteristics. on a very wide set of characteristics. And in terms of how that duty's been interpreted, I mean, the main point to make is it's been interpreted in various ways in the context of states which have education systems and schools that are running. So it's really the previous case law is not particularly useful or relevant to the current scenario, which is very different when most schools are not running and most children can't attend school. But any limitation of the right to education will only be compatible with Article 2 of the first protocol if there is a reasonable relationship of proportionality between the means employed and the aims sought to be achieved. I'm going to rush through slightly. The European Court has warned against a restricted interpretation of Article 2 of Protocol 1 because it's so important to democracy and the furtherance of human rights. And I won't read that. These are all available on the slides. I wanted to try and leave time for questions for everybody. The Article 2 of Protocol 1 has been considered to an extent in the UK courts, but again, in very different contexts, usually in relation to the provision of education to children who've been excluded from school or children who are disabled or unable to access, for some other reason, ordinary educational provision. It's almost been flipped on its head now that almost no children are able to access educational provision. But the test that the Supreme Court has approved is whether a child has been denied effective access to such educational facilities as the state provides for such pupils. So the two questions there are: what facilities are being provided and what does effective access mean? Equality Act, as you'll all be aware, public authorities must not discriminate and must have due regard to the need to eliminate discrimination, advance equality of opportunity and foster good relations between different groups. Keelan's covered off the UN Convention on the Rights of the Child, so I'm not going to refer to that. But just moving on to potential issues, the indefinite school closure, there must be that reasonable relationship of proportionality between the means, so in this case the school closure, and the legitimate ends. So protection of public health is a standard legitimate end, but what is the reasonable relationship of proportionality? How long will it be lawful for schools to be almost completely closed? And that will, of course, that question depends on the factual evidence of infection risks, of the current spread of the virus, and all the kind of things that are relevant to lots of other proportionality exercises in different areas that we're considering. But in the meantime, that restriction, which restricts almost all children, is bound to have a significant impact on vulnerable children. Yes, the state is providing the provision for vulnerable children, but no, most of them aren't attending. So if 95% of vulnerable children aren't attending, and at what point does the state have a duty to do something more? Because they're clearly not attending for some reason. Socioeconomic factors are going to come in quite significantly, as I discussed just in the very final point. There's huge discrimination risks, particularly on grounds of race, single parents. There's all sorts of very significant issues which arise. What does being denied effective access mean? And what is the extent of that Section 10 duty to promote education and the Section 19 duty to provide alternative means of education in when a child is prevented from attending because of sickness? Those are essentially untested duties in this context. And the second point, and just to finish off with a case that Keelan and I are involved in, it's pre-action at the moment, involving the Good Law Project. The Secretary of State has placed a huge reliance on online learning. There's a lot of resources have been recommended and produced with the BBC and the new Oak Academy, and there's lots of that being promoted to families and children. But what then happens to the significant number of families who simply don't have the tablets and laptops that you need to be able, phones that you need to be able to access that education? And that's going to have that reliance on online education is going to have a huge knock-on effect in discrimination terms, because people who don't have access are likely to be in lower, so in less advantaged, socioeconomic groups. There's a knock-on effect on race. There's a knock-on effect on other protected characteristics. So the Secretary of State has recently announced, following pre-action correspondence that we worked on, that there's a scheme, it's something in the tens of millions for providing laptops to certain categories of disadvantaged children in year 10 and others. I'll just finish off, there's two statements which you can read in the slides about from the Committee of the Rights of the Child and the Council of Europe. I think Aoife touched on them. Questions?
Thanks, Adam. That was brilliant. Sorry, I couldn't quite work out how to unmute myself, which isn't brilliant. We've got a number of questions. I'm not sure whether the panel have got time to run through them.
It might be better to start with the more technical ones, and then I can address Bruce's one at the end, perhaps.
Fine, okay. Has anyone been able to consider the technical questions at all?
Yeah, sure. So I suspect Adam may have a view on this as well, Shan, but there's a question from Linda Ewan about a case in Lewisham saying, what about a child in need who is out of education due to school phobia? So she's classed as vulnerable for the purposes of the guidance, but doesn't have a school to go to. She also doesn't have access to a laptop, currently receiving zero education. And Adam, you may want to supplement this, but that's a classic case where there is a straightforward obligation on the local authority under Section 19 to ensure that she is getting appropriate provision outside school. And this is where there's a fundamental gap, because this is a situation where there's minimal guidance coming in relation to children such as this from central government, but the statutory scheme places the primary responsibility on the local authority. So Linda, we can speak about it in more detail afterwards if you'd like, but in the first instance there's obviously a firm letter under Section 19 which needs to go to the London Borough of Lewisham from the summary you've given.
I don't have anything to add to that. I was actually going to answer Vicky Edwards' question, will the slides be available for us to access following the webinar? And the answer is yes.
Well, then I think it makes sense. Jamie, did you want to respond to any of the questions?
Well, an anonymous messenger has made a very good point that we could write to the government and indicate all of these changes are temporary, and that's a point that's already been made, in fact, by the Scrutiny Committee. And there's also a question here from, I might be mispronouncing the first name, I'm sorry, Aoife Williams, about whether or not the statutory instrument could seriously affect the rights of children under common law protections. I have to say at the moment, I don't think that's a risk that we need to worry about too much. But of course, one never knows. And of course, the more embedded these changes become over time, as I've already said, the harder it might be to dislodge them. So all the more reason to act now. And just on that, we've had confirmation from another participant that a letter for action has in fact got off to the Secretary of State about the legality of these regulations, probably focused, I imagine, on the lack of proper consultation and everything in advance of them being made law.
Okay, and I think, given that it's the last question, I'm just going to address Bruce's, and I'm going to read it out actually, because I think it's something that's useful for all of us who are involved in the webinar to hear. And Bruce says, there have been a significant number of statements from international human rights bodies, particularly the UN Committee on the Rights of the Child statement you focused on, yet very little reference to them by governments and policymakers. The Scottish Government has done a very limited child rights and wellbeing impact assessment on emergency legislation, and this week a short progress statement using the CRC issues statement. How can we ensure that decision makers are properly aware and take action upon the obligations and advice and recommendations available? There has been almost no participation of children and young people in these processes. How can we ensure decision makers see the importance of that? Now it's interesting because if Bruce, who obviously heads up a major NHRI, hadn't asked this question, I would probably have thrown it over to him to try to answer it, because what he's raising here, what you raise here, Bruce, as you more than anyone know, are some of the challenges that are faced in trying to have an impact on a political series of decisions, a series of political or policy decisions, and of course legal decisions, whether primary or secondary legislation. I think, though, what I would say is one of the biggest problems that we have had, I think, as the children's rights sector has had and other sectors have had in terms of actually having traction on decision making, whether policy or in terms of, you know, changes to legal structures, is that this is constantly, COVID-19 is constantly presented as an emergency or a crisis, okay? So everything's temporary, everything's rushed, everything's for the short term, even though it's very clear that actually some of the changes are probably intended to be long-term, as Jamie flagged. And I think really, in order to have, I'm not saying we've missed the boat here. What I'm saying is that I think we really need to push very hard and say, this is the new normal, okay? COVID-19 is not going to go away in the next 3 months, nor is it going to be the last health or other crisis of its nature that we've come across. And part of it is about focusing on future-oriented planning and possible models, you know, what should school closures look like rather than what have they had to look like. I mean, that's where I think the key emphasis has to be. And I do think that by framing arguments and advocacy and lobbying in that way, you will find people who are concerned about it and who will respond to that quite strongly. And ultimately, if we can build children's view into future proofing for future crises, at least something will have been achieved. But there obviously isn't. I mean, you of all people know that there is no magic wand, but it is very clear that if we're looking at school closures in 6 months' time, because it's winter and COVID-19 comes back, then the government cannot be allowed to talk about emergency crisis, short-term plan, you know, the need for short-term measures, immediate measures to be used as an excuse for not taking children's rights into account. So I think maybe it's about saying we're not just talking about the here and now, we're talking about next time and this new normal that we know is where we are and the things that we know are coming down the track. So not a very satisfactory answer, but I think maybe that's a way of shaping political advocacy around this, given that frequently the response so far has been, oh, no, we've had to do this. There's no other options available to us. We've had 48 hours, etc., etc.
Brilliant. Well, thank you very much to our panel and thank you to everyone for joining today. The slides will be emailed around to you with those additions that were missing slightly, and a copy of the recording will also be circulated to you all. And we hope to see you for part 2. You can register on the website, or you should have had the link already. And if we can be of any assistance, please don't hesitate either to get in touch with myself or one of the panelists directly. But thanks again for joining. Right, bye.
Thank you.